Good evening, Your Excellencies, and may it please the Court. My name is Alejandro Soto, and I am the Senior Counsel for the Respondent, Her Majesty's Government of the United Kingdom of Great Britain and Northern Ireland. I'll be addressing the first ground of appeal that Her Majesty's Government, in its sanction against applicants, acted in a manner prescribed by law to address the pressing social need to both promote public safety and address the troubling rise of racially aggravated assaults in light of the COVID-19 pandemic. May we kindly remind the Court that the burden on the respondent today is to only show that Her Majesty's Government did in fact comply with the obligations of Article 10 in order to impose restrictions on speech necessary in a democratic society. Unless otherwise indicated by the Court, I propose to make the following three submissions. 1. The interference with speech was adequately prescribed by law and thus foreseeable. 2. The interference with speech pursued the legitimate aims of 1. Addressing both public safety and 2. The rights of racial minorities from discrimination and harassment. And 3. The interference with speech was proportional under the degree of appreciation for balancing rights afforded by the Court. To begin, Her Majesty's Government does not contest that speech, in its most broad definition as applied by the opposing counsels, was interfered with through the sanction of 2 years imprisonment. However, the Court has long held that a degree of appreciation is permitted for national governments to be flexible in their law enforcement to account for various situations that perhaps cannot be precisely accounted for by the law. We again cite Terentyev versus Russia as an authority on that assertion. In that case, the Russian Civil Code, specifically Article 282, was construed so as that hatred of, quote, social groups, end quotes, meant hatred of the police force, thus justifying the conviction of Ms. Terentyev. In its majority opinion, the Court wrote that it has, quote, consistently recognized that laws must be of general application with the result that their wording is not always precise. It is true that the need to avoid excessive rigidity and to keep pace with changing circumstances means that many laws are inevitably couched in terms which, to a greater or lesser extent, are vague, end quote. In Terentyev, the Court found that the Russian government's sanction was in fact prescribed by law. In Terentyev, as well, the Court found that Russia had acted upon a pressing social need of protecting law enforcement in applying the ambiguous term social group, establishing no violation. As such, we submit that the prosecution of the term subjective apprehension of immediate violence, acting in accordance to the pressing social need I'll address in my following submission, was in fact prescribed by law and thus foreseeable. In the alternative, we refer the Court to Gingiss 1986 as a comprehensive linguistic analysis of when speech becomes an indirect threat. We note that under the guidelines of Gingiss, it clearly demonstrates applicants' words constituted a threat. We note that in the recent case of Adamanchuk versus Russia, the Court considered a similar linguistic and psychological analysis to determine whether the applicant's public remarks were considered an implicit incitement of violence against minority groups. We submit that this Court can consider a similar analysis to determine whether the speech of T and others was an indirect threat rather than protected political speech.
Right, thank you, Counsel. But there is a fine distinction between incitement of violence and perhaps what is and political speech, because incitement of violence requires for an individual or a group of individuals to incite violence from a larger group of individuals. If there is no violence incited, then we can't say that there is an incitement of violence.
That is correct. Your Excellency, and we are not making the argument that what the applicants did was in fact an incitement of violence. However, what we're arguing is on the precedential matter in that in Adamanchuk versus Russia, the Court found it right to consider the linguistic and psychological analysis. In our alternative submission, that is what we are proposing to the Court, that they also consider this analysis when determining when in that case it was incitement. In this case, it's indirect threats.
Counsel, may I proceed?
Certainly, Your Excellency. Next, Her Majesty's Government's interference with speech pursued the legitimate aims of addressing both public safety and the rights of racial minorities from discrimination and harassment. Again, in Terentyev, the Court held that the government of Russia, in its sanction against the applicant for criticizing the police in a blog post comment, pursued the legitimate aim of protecting the rights of others, namely the reputation of the police force. Her Majesty's government notes that the application statement of agreed facts makes apparent that the United Kingdom has faced, quote, an increase in racially aggravated hate crimes against those of an East Asian ethnicity due to the perception that many people of an East Asian ethnicity are spreaders of COVID-19, end quote. Similarly, the application of the Hate Crimes Act, or HCA, as a criminal statute followed the law as written, wherein, quote, a racially aggravated assault is committed if the offender intentionally or recklessly causes another to suffer or subjectively apprehend immediate unlawful violence, end quote. With these two facts in mind, we submit that the respondent's sanction pursued the legitimate aim of protecting the rights of others, namely those of racial minorities facing a rise in hate crime against them, and protecting public safety against the use of threats that would indicate immediate unlawful violence. Finally, Her Majesty's government asserts that its interference in the speech of applicants was proportional under the court's margin of appreciation for balancing rights. In the case of Evans versus United Kingdom, the court held that Parliament was afforded a wide margin of appreciation when balancing the private right of the applicant to seek an in vitro fertilization treatment to the public right of the respondent to legislate on social policy and sex discrimination under Article 17. In our case, Parliament seeks to balance the private rights of the applicants to speech with the public right of the East Asian community to not face discrimination and xenophobia. We note Ferét versus Belgium to support this argument, wherein the court did not even need to bring up Article 17 because of its holding that, quote, fostering the exclusion of foreigners was a fundamental attack on their rights, end quote. Thus, we submit that in balancing the rights of applicants and ex, Parliament's decision to not include sentencing guidelines, and rather leave it up to the courts and UK jurisprudence, was a proportional measure in order to account for the extreme pressing social needs of racial minorities facing a rising in hate crime against them, and thus requiring that margin of appreciation in order to be flexible in its ruling and determine what was necessary in that particular instance. In the alternative, we submit that in this case, a reasonable person would expect that if Parliament thought a situation was so dire that it had to write a law on top of the Public Order Act 1986, then the prosecution of the law would be in pursuit of a harsher sentence. This falls well within Her Majesty's government's margin of appreciation, as we have previously established, in order to balance laws made 34 years ago and the novel threats to minority rights as presented in the COVID-19 pandemic. At this
Thank
time,
you, Counsel.
Mhm.
Can you hear me?
Yes.
Oh, right. Okay, excellent. So you say that just because Parliament passes a law on top of another law, given the circumstances, we should listen to Parliament. So does that mean that if they strip rights away from other people just because they pass another legislation on it, we should listen to them?
Thank you, Your Excellency, and that is a great point to make. We are not making the assertion that Parliament has any kind of absolute authority with regards to criminal statutes, or that it has the right to strip people's rights on the account of whether Parliament deems that there is a situation requiring it. What we are asking for from the court, and what we believe has been established in prior ECHR case law, is that when we are talking about a balancing of rights, a balancing of people's right to speech and people's right to not face xenophobia and discrimination, then Parliament can have a bit more leeway in crafting its laws in a way that perhaps relies on the judiciary's independence and the judiciary's opinion of what would be a good sentence.
Yes, correct. But that does seem like a circular argument, because what we are trying to argue is that Parliament should have more leeway in crafting the laws. And your argument to that is that Parliament has sovereignty in crafting the laws. And that seems to me rather secular, doesn't it?
Well, it's well established in UK case law that Parliament does have sovereignty in establishing its laws. What we're saying here again is that the wide margin of appreciation allows for Parliament to delegate the authority of sentencing guidelines to the judiciary as a means of making the case more flexible, noting the novel circumstances of the public emergency.
You may proceed.
In fact, that is the end of my submission. Thank you, Your Excellencies, for your time, and we will now lead to the Junior Counsel.
Okay, that is fine. Junior Counsel, are you ready?
Yes. I've turned my camera off because I'm not sure about the Wi-Fi, by the way, so that's fine.